Justices of the Appellate Division, 4th Department. Hear ye, hear ye, hear ye. All persons having business to do before this court shall draw near, give their attendance, and shall be heard.
Thank you. Please be seated. The first case on for argument today is case 838, People v. Crawford. Proceed, counsel.
Good morning. May it please the court, Bridget Field on behalf of Mr. Crawford this morning. I'd first like to touch on the Arama issue I raised. I think it's very clear the judge did not read the note. There's the record.
We're talking about jury note, what was it, Court Exhibit 18?
Exactly.
And there was a paraphrasing by the judge.
Yes,
and there's no indication in the record that that note was shown to counsel?
No, there is not. I think it's very clear. I disagree with the prosecutor's argument that we should
And there's no real disagreement that this was a substantive note?
Correct, correct. This had to do with statements and video, the video evidence that was very, very relevant. This was a circumstantial case. No one viewed the shooting. It was a significantly substantive note.
And it doesn't matter in your view. Mr. McCarthy suggests that off the record, the lawyers may have been privy to the note and they discussed what the response was going to be. In your view, that doesn't matter. It has to be done explicitly on the record. It has to be read verbatim.
I believe so, yes. And I disagree with what, there was the discussion on the record by the court was about both juror note 17 and 18 at the same time. So I don't see the indication on the record that this had been discussed off the record. Sometimes there is, judges or the parties will come back into court and say, we've discussed this, we've looked at it. There was no such indication in this record that that had occurred. I mean, there was also, there just was no further discussion. And the paraphrasing omitted significant portions of, I mean, it was a short note, but there was a significant portion. This wasn't just one or two words. It was a portion of the note that was relevant to identification of Mr. Crawford. And a key issue in this case, as nobody observed the shooting, and that leads me into my next issue about the video in this case, the surveillance is, I apologize, I'm losing my voice this morning. The surveillance video, which I believe was People's Exhibit 15, I could be wrong on that at this point.
Before you move to the next topic, just on the previous one, it looks like that the witness that was, whose testimony was read back, or the video was read back of her testimony, Ms. Matthews, that when she talked about not seeing the defendant until she viewed the video, it looks like that was pages 1330, 1333 of the record in there. And then later in her testimony, 1372, 1373 of the record, she talked about how she saw the defendant on the video at other times. At other times she watched the surveillance. I think she was looking at the cash register to make sure that somebody wasn't stealing. Just other occasions,
okay,
separate
yes.
days. It looks like the juror note 18, the one that we're talking about on the Arama issue, what the judge left out was that reference, the reference to multiple times when she was not at the counter, but through the video saw the defendant. That was the part that the judge paraphrased or excluded.
Correct.
Do we know whether the jury got a readback of that later testimony, or did the jury not get the readback because that part was missed? Do you understand my question?
I believe I do, and I certainly would defer to you on the pages in the transcript this morning, but I don't think there's any indication on the record what was actually read back.
Got it.
They just, the judge indicated there'll be a readback, and there's no indication from the court reporter where that readback started, where the readback ended, and if she picked up more than one portion. Oftentimes, too, a judge might say that, we're going to read the different portions. There was just absolutely nothing in the record to indicate to me what exactly was read to the jury, and if, in fact, the judge had looked at more than one point in the testimony, because Ms. Matthews had, in fact, there was testimony that she knew Mr. Crawford as a child, and then was also working as a waitress at the This Is It restaurant and had seen him then, but her description of seeing him then was he was a customer. It wasn't, like friends getting together again. She said there was no indication that it was anything along those lines. So I think it's very, very possible that that could have been missed. And again, very important that the note was paraphrased to the attorneys instead of read verbatim, because this is what could have led to that perhaps being missed to the jury on the readback. And the verdict, if my recollection is correct, was fairly quick after this note. It was about an hour after this conversation, colloquy had happened regarding note 17 and 18. And there certainly was a lot of back and forth about the video and notes. We were at note 18, Court Exhibit 18. There were quite a number of notes in this case and quite a number of issues back and forth about looking at that video. I believe on one occasion they asked to see the video 6 times. There was questions about could they stand near the video. There was definitely interest in viewing the video in the way that they could view the video, and whether the jury was able to talk about the video when they were viewing that. And that was kind of tied in with these exhibits, the Court Exhibits 17 and 18.
Counsel, you should begin to wrap up.
I would just like to very briefly touch on the argument about ineffective assistance at counsel. And I would note that Mr. Crawford touched on that issue as well in his supplemental brief, augmenting the argument that I had made. Bree Plummer had testified at the grand jury, and she identified Mr. Crawford as the shooter in this case. And at trial, Ms. Plummer would not testify, took the fifth, and indicating that she may have lied in the grand jury. Given the lack of evidence, there was no eyewitnesses to the shooting again. The video which has been provided to the court was very grainy, very blurry, very difficult to identify anybody in. We had witnesses that identified him as a person in the video but who were not present. And the failure to renew his motion to have the grand jury, defense counsel's motion to have the grand jury minutes looked at again, I believe was error with no tactical reason. It would be rare for this to be a successful argument, but given the specific facts of this case and the fact that we had a witness who now is taking the fifth and refusing to testify after she had testified in the grand jury, leads to the conclusion that she lied in the grand jury. And this is a significant issue that should have been looked at again by the court.
We'll take a look at that. Thank you, counsel.
Thank you.
Good morning, Your Honors. Marty McCarthy for the people. Yes, Justice Whalen, the note was substantive, and yes, it wasn't read verbatim. Yes, Justice Nowak, we actually have no idea what was read back, but that's one of the limitations of readbacks. The stenographer can't take down what they're reading back. But when you look at the context of the note...
Wait a minute, Counselor, stenographer can certainly say what they're reading back before, and say, I am reading back lines X through Y.
Well, this was from 2014, so I actually don't know if they had a computer system, the dual that the court reporters have now, which is a computer screen on their stenographer machine, as opposed to some of the old school stenographers who just have the machine without the computer. So I actually we don't know whether this court reporter had the benefit of line numbers at the time. But even with respect to that, when you look at the context, and you looked at what the Court of Appeals said in Ramirez, if the context reveals that the parties saw the note, then there's not going to be an Orama issue that the counsel's going to have to object.
Can we say for sure that the lawyers saw the note as opposed to the court paraphrasing it or reading it in some fashion to them?
Well, it's funny you should mention that, because in Ramirez, they couldn't say for sure that the court, that the parties saw the note, but they concluded that it was likely that the parties saw the note. And then when you pick up the transcript at the portion in which the parties come back, it's not the court paraphrasing the notes. It's the attorneys working on the notes. Like, how would they had to queue up the video to the locations that the jury had asked for without seeing the note. If they didn't see the note, they wouldn't have been able to do that. So when you look at context, they had to have seen the note, because without seeing the notes, they couldn't have queued the video. With respect to the video itself, no, the video wasn't grainy. It was properly admitted. Both the custodian and somebody who was there that day testified to the contents of the video and the contents of which the system was kept. The video was properly admitted. And with respect to, I think that's all I have, actually, unless you have any questions.
That's fine, thank you, Counsel. Case 839, People versus Walker.
Good morning, Your Honors. May it please the Court, Guy Talia on behalf of Defendant Appellant David Walker. This appeal may readily be decided in favor of my client based on what we'll call the LIPCA issue. Supreme Court plainly erred in denying the motion to suppress.
Counsel, let me ask you a question. What specifically is required here, right? I mean, you've got an officer in a car who punches in a license plate and gets a readback that, according to the officer, indicates that there's some suspension based on insurance or words to that effect, which prompts the officer to then pull the car over, right?
Correct.
So when that's challenged on a motion, what, and the burden shifts back to the people to demonstrate that that the information was reliable, what's
Accurate.
required?
So in this instance, I think what would be required was some sort of records from the Department of Motor Vehicles, or perhaps an employee of the Department of Motor Vehicles, to come in and actually say, here's our certified records demonstrating that at that time the insurance had in fact been lapsed on that vehicle. Because what the officer is receiving is just sort of an electronic communication from another agency, and the law is very clear that once that information is challenged, and here my client,
So you're
directly
saying an
challenged.
actual body, a person from DMV has to come in with the records to demonstrate that? Would a certificate of some, like happens in a lot of these DWI cases where we get the pile of certificates and they're all marked and accepted, would a certificate from DMV be enough to demonstrate that on this particular date, if a request was made relative to this license plate, this would be the information that would have been provided?
I think so, Your Honor. I don't think they need an actual body to come in. I think that, and especially given, the fact that DMV records are, have some indicia of reliability to begin with because they're so commonly used, but I think it has to be more than the officer's testimony. This court has held that in both Seawright and Dorch. But yeah, a certificate I think would be sufficient, but they didn't even do that here.
Counselor, can you clarify something for me?
Sure.
Okay, so we're talking specifically about what the officer saw or what the actual record is? And you understand the difference I'm making there? Like, if, for example, if it was a mistake coming from DMV, but the officer relied on that, are the people okay? Or if a mistake was transmitted, it doesn't matter. If his license wasn't suspended, people are out of luck.
I think the people are out of luck if they're relying just based on what the officer saw on the screen. I think the case law is very clear. If there's a presumption of reliability, and if it's not challenged by defendant, then they're okay. But here, the distinction is that my client clearly challenged the reliability of the information. He presented his own evidence saying, in fact, that it was incorrect.
Well,
and then once
he
that happens, the
didn't-
people have the burden of actually producing their records. The reliability, I think they say, disappears at that point. I think that's
Let
the
me
case
ask
law.
you, just going back a step, what does a defendant have to show in the moving papers, if anything, to shift that burden to the people to produce some documentary evidence or testimonial evidence on the registration status?
Well, Your Honor, I think that may depend on the type of information
Well, here,
that's received.
your
Here-
client submitted an insurance card for a Chevy. That it was a different car.
Okay.
Yeah, I mean, I have it right here. So the insurance card itself said that there was a Chevrolet that was insured for this time period. That your client was not driving a Chevy. He had a Pontiac.
Correct.
So, but he did have another document in there, verification of insurance, which referenced this Pontiac.
Correct.
But do you need, did your client need any of that? Or is it enough just to say in the motion papers, the registration was not suspended? Is that enough, or do you need to have some documentary proof to then put that burden on the people?
Your Honor, I think that generally it's enough to just challenge the reliability of it. If you put it in your motion papers, I think the courts have accepted very general challenges to the
Does it
reliability.
have to be in an affidavit, or can the lawyer just say, we challenge that?
If I'm going back, and my recollection of the case law has accepted pretty general challenges to the reliability of information. I would say, though, for this case, I don't know that we really need to decide that because he had such a strong
I'm just trying
challenge.
to figure out what the rule is.
And I think, Your Honor, it's kind of interesting because this case presents a little bit of an open question in terms of whether a general challenge would be sufficient or whether what my client did is required because it's DMV records. I mean, sometimes, the evidence is, a judgment call, someone's description of a witness, someone's description of a vehicle. And in that case, I think it might be a more general challenge.
Well, if
is
a specific
acceptable.
objection is required, your client just showed evidence that the vehicle was insured on the date he was stopped. That doesn't necessarily follow that the registration wasn't suspended for an insurance lapse. You can have an insurance lapse. If you're driving around with insurance to court today, doesn't mean that your registration hasn't been suspended due to a lapse from last year or 6 years ago. So what the people look at it is that proof of insurance here doesn't prove anything. The screen said suspended, registration suspended due to an insurance lapse. Doesn't say when. So they don't even think you shifted the burden for that reason.
I think that my client, whatever he did, saying there was insurance in place on the date in question when it came back to reading, it didn't say registration suspended, it said insurance lapse. And I think
No, it said registration suspended and then insurance lapse was the reason for the suspension. That's what the DMV said, according to the officer.
I think, Your Honor, not to get into debate on that issue, I don't know that that's that important, but I think the teletype report just said insurance lapse, and he testified that technically that means the registration is suspended, but I think the information just said insurance lapse. And I would think that what my client did was demonstrating with affidavit and documentary proof and testimony at the hearing that insurance was in fact in place on that date in question. That's clearly more than sufficient to trigger the people's obligation to say, no, there was an insurance lapse.
But your
on the
argument
date
goes
in question.
further, though. You're saying that, I think what you're saying is, yeah, in this case, we do have some evidence that insurance was in place at the time of the stop. But you really don't need that to shift the burden. It's the people's burden to
Right.
demonstrate that there was a basis for this stop.
Correct.
And once it's challenged, then it shifts to them. They have to bring something in from DMV. That's your argument, right?
Yes, Your Honor, that's correct. Yeah, I think we did more than we needed to shift the burden to the people here, and they clearly did nothing to attempt to meet it.
What about preservation? Was the argument preserved below?
Well, I think it was preserved by the fact that he challenged, he clearly challenged the reliability of the information.
It goes to the specifics, though. How specific was the challenge below? Was it specific enough to bring into this issue that we're discussing today?
I certainly think it was, yeah. I mean, there's no magic language that's required. I think that this issue, there was a kind of a situation like this in Dorch, in this court's opinion in Dorch, where there wasn't specifically any magic language used, like I'm making a likely challenge, but they did just challenge the reliability of the information, and that was held sufficient there. So I don't think there's any issue here. With respect to preservation, he directly challenged the reliability of the information, and.
All right, thank you, counsel.
Like I said, I'll just rely on my brief for the remaining arguments.
Very good.
Thank you, Your Honor.
Morning,
Counsel,
Your
we're
Honor.
obviously focused on the suppression hearing.
Yes,
So
clearly.
if you'd address that, that'd be helpful.
Yes, presuming that LIPCA does apply to the information in this case, which was DMV records, they didn't challenge the DMV records with respect to the registration. The insurance information, as Justice Lindley had pointed out, was only current in the sense of it didn't encompass the registration period. I mean, the registration period is 2 years in New York. So as Justice Lindley pointed out, it didn't matter whether they had insurance on the vehicles that day. What mattered was...
By raising the issue, right, and shifting the burden back to the people here, isn't it up to the people to come forward with some evidence? Whether it's a certificate from DMV or a person from DMV that's going to come in and say, yes, on that date, there was a suspension, so that if the officer did put the plate number in, the information that would have gone back would have been consistent with what the officer testified to.
Well, it's funny you should mention that, because as I recall the record, the witness never testified at the hearing that the registration was valid. She only talked about the insurance. So when you talk about what did they put in issue, they never put the registration in issue. They put the insurance.
But she did testify that her insurance had never lapsed, ever. She got some notices of cancellation. If you don't pay your bill, your coverage will be canceled. But she categorically said it was never canceled, so there's no lapse. So then, therefore, there would be no suspension for lapse.
Except for the fact that, again, if you're going to place the issue of whether she had a valid suspension in issue, then it was incumbent upon them to come forward with the registration. They didn't.
Did the computer screen say, according to Officer Rizzo, we don't know what it said, that's part of the problem, but his testimony was that he punched in the license plate number for the Pontiac. It came up from DMV, it said suspended -- insurance lapse. Is that your understanding?
I believe so. And that would just be one reason in which a registration could be suspended. But you wouldn't get a return from a license plate that there was an insurance lapse without a suspension, unless, of course, the insurance lapse had been cleared up and the suspension on the car had been lifted.
Now, if, as Justice Whalen indicated, if just a general objection in the motion papers, a general challenge to the reliability is enough, then it doesn't matter, this difference between having insurance and being suspended doesn't matter. Do you believe more than a general challenge to the reliability is required?
So when you look at Mendoza pleadings, obviously, typically in typical Mendoza scenario, it's the people that have all the information, and the defendant doesn't have the information. So when you look at the defendant's motion, it has to be judged on the Mendoza standard based on their access to information. Here, they're the ones with the information about the suspension. It was the defendant's vehicle, or I believe he used the vehicle, and it was used by somebody, it was owned by somebody he knew. They were the ones with the information. And when they have the information, it's incumbent upon them to actually put that information in the motion.
Isn't the question the question is not whether the DMV information that was relayed to the officer was correct or not. I think I want to know whether or not it was relayed to the officer. In other words, there may have been a problem at DMV. Maybe there was an error at DMV. But if the information came from DMV to the officer in the car, that was the information that he was provided, that seems to be the right question. Because he should be able to rely upon information coming from DMV in the car in that moment.
Correct.
Not doing some research to make sure and confirm that that information's accurate.
Correct.
Right?
Yes.
And it seems to me that that should be the question, not whether or not it was accurate, but whether it was conveyed in that manner. Because otherwise, we have officers who can say, yeah, that's the information that came through, and we either believe the officer or not, and there's no further need to demonstrate anything. But I think there is a need to demonstrate something more.
Well, you've never held that before in terms of what we would have to show for an officer receiving information from DMV. And the other thing that happened was he was never impeached on, oh, here's the Dahl report, this is the Dahl report that you generated. It didn't say what you said it said. That didn't happen either. That's the other thing to remember. I mean, defense counsel certainly could have impeached on that had the Dahl report not said what the officer said it said.
Couldn't, it doesn't seem a terribly unreasonable burden, though, in a case like this, where the defendant charged the course early, saying, hey, I don't believe that that information is accurate, does it before the hearing, has some documentary proof. It's not an unreasonable burden for the prosecutor then, who has time to just look at the DMV records, print them out, and bring them to court. That doesn't seem like an unreasonable burden. I would agree with you, if the defendant says nothing and then springs this at the hearing, then the prosecutor's not ready, but this defense was charted early, and the prosecutor didn't do anything by way of documentation or evidence to rebut it.
I would say that it's not a complete defense, only because he didn't, again, he did not put in issue the issue of the registration. He only put in issue that he had insurance on that day, and that's it, which is not the question. The question goes to whether the registration was suspended on that day.
And it could have been suspended for a lapse beyond the policy period.
Especially when you consider her testimony about not paying the insurance bill. And to me, it doesn't seem credible that, that she wasn't suspended previously for not paying the bill. Are there no other questions?
Well, the officer, though, I mean, we don't know what exactly was on the screen. We don't know we don't know exactly what the officer typed in. The officer claims I typed in the license plate correctly. Theoretically, could have tried to and hit a B instead of an M or something like that, right? So we don't know, and so we have the statement that he typed it in correctly, that he typed it into the screen correctly, as well as exactly what it said, which was suspension .. insurance lapse. We have then the defendant bringing a witness to the suppression hearing saying, that's funny, the insurance never lapsed. So that doesn't really make sense. It's not incumbent at that point then to show that, well, yeah, at least he typed it in correctly, the insurance did in fact lapse at some point.
Now, let me ask you this.
You don't get to ask questions. It may seem unfair.
It was going to be rhetorical. I promise. Let me put it this way then. Had the officer typed the license plate in wrong, the defense attorney would have cross-examined him on that. And if that had happened, then the defendant would have been entitled to suppression, because in that scenario, he didn't have probable cause to pull that vehicle over for a V&T violation.
Well, it could have been a good faith mistake, but
I don't know.
Here it didn't. It came up for a Pontiac G6, so the screen indicates what type of vehicle it was. It matched,
Yeah.
and he testified he saw. So there wasn't a mistyping.
No, and if that had happened, the defense counsel would have exploited that.
Fair enough.
I
Thank
promise, no more questions.
Thank you, counsel. Case 841, People versus Nixon.
Good morning, Jonathan Garvin for Appellant Lombard Nixon. May it please the court. We urge this court to hold off on deciding this appeal until the Court of Appeals decides the cases it heard on September 6th. If there are no questions, appellant relies on its brief.
No questions, counsel. Thank you.
Thank you, Your Honor.
Case 842, Gear versus Collazo. Just wait 1 second, counsel, until everybody gets situated. Thank you very much. Please proceed.
May it please the court, Timothy Davis on behalf of Mr. Gear. Unless the court has any questions, I would rest on my papers.
Thank you, counsel.
Thank you.
Good morning. May it please the court. Cynthia Carroll on behalf of the respondent, Joanne Collazo. I will keep it brief. In matter of Bailey versus Bailey, this court concluded that evidence that a child's health and safety were compromised while in a parent's care is sufficient to rebut the presumption of visitation. In this case, the child at issue health and safety were repeatedly and egregiously compromised in the care of the appellant. The cases cited in the attorney for the child's brief, furthermore, all involved a misconduct by a father against a mother and a lack of understanding and appreciation on the father's part as to the effect of that on the child. In all of those cases, the court found that the presumption of paternity had been rebutted. I'd like to address the issue regarding the request for photographs and updates. There is a sound and substantial basis in the record for the referee's determination not to grant that relief.
Did the court actually address that request?
I think the court did address it in the decision. He said that he denied the other requested relief. I don't think he spent time specifically going into the reasons why, but I do think there is a sound and substantial basis in the record to support that conclusion, and I'd like to explain why. All of the third department cases cited by the appellant are cases involving a prisoner. There are also cases where the granting of that relief was not actually before the appellate court. This man is not any longer in prison. This mother has a long-term no-contact order of protection against him. She's got addressed confidentiality in family court. There was evidence of repeated violations of orders of protection before the court. To require her to stay in contact with him, in fact, there is a sound and substantial basis for the court to have concluded that that would not be safe for this child. Furthermore, given the...
It wouldn't be safe for the mother either.
Correct. For the mother
The trauma that she experienced at the hands of the appellant.
Absolutely, and it risks re-triggering her, and she is the only functional parent of this child. So in conclusion, I would state that, this appellant kidnapped the mother over an extended period of time. The child has ongoing and significant trauma, as does the child's caregiver. I respectfully request that this court affirm.
Thank you, counsel.
I really have nothing to add. I would rest on my papers unless the court has questions for me.
No questions, counsel? Thank you. Case 843 in the matter of Shania R. Proceed, counsel.
Thank you, Your Honor. I am Charles Greenberg representing Shana R. in her appeal from the adjudication that she had neglected her biological daughter, Shania. I do note that the biological grandmother is Shania. Having reviewed all three briefs, Your Honor, and I think the parties agree as to what happened on September 30th, 2020, which precipitated the neglect position, that a friend of the grandmother's apparently stabbed a friend of the mother, and the mother responded by running her over in the car.
And the child was in the back seat?
And the child was in the back seat, yes. So I think that the only real argument, the only real matter of legal dispute is whether that constitutes neglect as defined by Scopetta and its progeny of cases, whether baby Shania was affected by any of this. The fact that she may have been present is...
You don't think a child who sees her grandmother run over by a car, go flying in the air, and land on the cement,
right?
You don't think that has any detrimental effect on the mental well-being of the child? To actually see her grandmother, who she was upset about seeing this happen, the mother intentionally ran the grandmother over. It wasn't self-defense.
Right.
And it sounds like the mother brought the child, this was premeditated. The mother and her friend drove to the grandmother's house to assault her for some reason. And she decided to bring her child with her.
Well, I would agree with three-quarters of what you said. And I don't think it was premeditated that she deliberately went to the grandmother's house to assault her, because the grandmother actually may have initiated the assaultive narrative by stabbing the friend in the front seat of the car.
My understanding was the mother and her friend were driving to the grandmother's house because there was a beef of some sort. Do you agree with that?
Well, I mean, there may have been a beef, but I don't think her intent was.
But they
to
went
assault
over
her.
there not to have dinner and to exchange pleasantries. They drove over there angry, and the mother decided to put the child in the car for this confrontation. The grandmother then stabs the friend. The mother could have driven the friend to safety. Instead, she took the car, backed up at high rate of speed, and almost killed grandmother in front of the child. That's not going to have any effect on the child?
Well, I don't want to say it would have any effect, but does the effect rise to the level that Scopetta and Nicholson demands, that there has to be an immediate danger, an immediate threat to the child, and not some theoretical.
But that threat doesn't have to be physical, it could be emotional.
It
You'd
could
agree
be
with that?
emotional, it could be, it could be, but I think it has to be a real threat. It can't just
Right.
be, well, you saw, something terrible happened and therefore she was threatened. The other element I would also say is that I think there was an allegation of improper supervision, but the counsel for the department during the service, during the fact-finding hearing, stated that leaving Shania with the biological father, who has since been adjudicated the legal father, a gentleman named Richardson, that was an appropriate plan for the child. If there are any other questions?
We'll take a look at that, counsel, thank you.
Thank you.
Good morning. On behalf of the department, Benjamin E. Mannion. Just briefly, Your Honors, to go to the Scopetta argument, there was testimony that was elicited at trial that the child did cry as she watched her mother run over her grandmother with the car, and then stated to CPS worker later on that she had cried because she was concerned about her grandmother. So I believe that the testimony that the department elicited at trial rises to the level of demonstrating an emotional harm to that child as a result of the actions that they saw. Also, briefly, Your Honors, I would just note that as acknowledged in the appellant's brief, the appellant's argument in whole is not preserved for review before this court. As acknowledged in the brief, the appellant failed to make a motion to dismiss the department's petition at trial, and the only argument that was made at trial was an argument on summation that the trial court should dismiss the petition merely because the appellant was trying to defend her child during the course of the action. So as noted in such cases as Porter v. D'Adamo, 113 AD 3rd 908, as well as In re Brandon v. 133 AD 3rd 769, a child support case and a juvenile delinquency case, as well as innumerable cases throughout New York state law. The department contends that appellant has failed to preserve their one point before this court, and the department would just ask that this court affirm the trial court's decision. Thank you.
Thank you, counsel. Mr. Fox?
Thank you, Your Honor. May it please the court, Russell Fox, Legal Aid Bureau of Buffalo, attorney for the child. Unless the court has any questions, we would rest on our brief.
Thank you, sir. Case 844 in the matter of Jalian F. Very good, counsel. Can you hear us?
Yes, Your Honor.
Very good, we can hear you very good. And Mr. Is it Haydu?
Hoydu, Your Honor.
Haydu, my apologies, sir. We can hear you fine also, thank you. Please proceed.
Good morning, Your Honor. Joseph T. Jarzembek, counsel for appellant Angelina. May it please the court, Your Honor, this is an abuse case out of Erie County. My client was charged along with 4 other, or maybe 5 other, lost track of the number of co-respondents on this case, in an abuse case involving her young child, Yolena. My client put on an affirmative defense in this case, and the standard on these cases has been elicited or pursuant to the matter of Philip M. It's our position that the department did not substantiate a case of abuse against my client specifically. My client did take the stand. She was on the day in question on July 5th. She was actually employed at Chipotle, was dropped off, as the facts indicated, by her boyfriend.
Counsel, just so I understand, is it your position that the court simply, in listening to the testimony, I understand that the trial took place over about 4 days, and there are a number of witnesses, including your client, that the court, in making the determinations on credibility, who to believe, who not to believe, and looking at the timeline here, that was not an appropriate way to weigh the evidence and to make the determination that your client's conduct was at cause here?
That is correct, Your Honor.
Very good. Anything further?
Nothing really. I will rest on my arguments, the rest of the arguments that are in my brief as well.
Very good. Thank you, Counsel.
Thank you, Judge.
Again, on behalf of the department, Benjamin E. Mannion. Your Honors, the department rests pending any further questions on the papers as to part 1, or point 1, correction. As to point 2, the department would just point out yet again that appellant in this instance withdrew their motion for a new trial and a motion to reopen the trial during their written summation, leaving this matter unpreserved for review before this court. However, if the court finds this issue was preserved, the appellant prevailed on their motion at trial. The mistrial or new trial was merely an alternative form of relief that was sought, but the appellant was allowed to reopen and was allowed to call additional witnesses. As to the Brady allegation that is brought up, appellant counsel does not make any type of argument regarding any of the standards for a Brady argument, and in fact, trial counsel in this matter had the evidence that was requested and all of the information at trial. Therefore, there was no exculpatory evidence that was withheld from the appellant in this case. It was all before them at trial. Pending any questions, the department knows. Thank you.
No questions, Counsel. Thank you. Counsel?
Support Lyle Hoyt, attorney for the child. I support the department's position for the reasons that have already been stated, and would respectfully request that the family court find an abuse return. And unless this court has specific questions, I'll rest on my brief.
Thank you, Counsel. Case 845, Lampack versus Andrews. Proceed, Counsel.
Good morning. Victor Prowl on behalf of the defendant, third party, plaintiff Richard Andrews. Your Honors, I want to start with, so there were multiple motions. As you know, the judge denied all of them. My client owns this small building in Lowville that was an ice cream stand. So it was operating only during the summer months. When the DMV came on as a tenant, they were going to perform all of their own modifications. They did install a ramp, install a deck. My client was classically an out-of-possession landlord. He didn't even have keys to the premises as a DMV building, so there were government records in there. So he was not there. He had absolutely no knowledge of any alleged dangerous condition.
Let's say, Counsel, for the sake of argument, that there's evidence that your client installed a gutter that was defective and it provided for water being coming on to the area where the plaintiff slipped and it froze and so forth. The plaintiff says that's creation of a dangerous condition.
how are they wrong that there's at least an issue of fact on actual creation?
If there is any evidence, but there isn't any evidence, and the plaintiff actually admitted in the papers, it's in the record on page 1074, that the plaintiff, that my client did not create the condition and did not have any knowledge of it.
Did the county put the gutter on?
Yes. Yes, the county put the gutter on. Not only did they do that, they maintained it. There's testimony in the record that the county DMV employees would, the county employees would come over to the DMV and pour salt into the gutter to apparently attempt to lessen the issue. But there's no evidence that my client had any awareness of this gutter condition. So the only exceptions to the out-of-possession landlord rule are if you have an obligation to repair in a contract, which doesn't exist here, if you have the right to enter and a structural defect or violation of a statute, which you also was not alleged here. If there is a duty, which there is not one, he didn't create it, my client didn't attach it, he never maintained it. Plaintiff admits...
Didn't your client replace that, the ramp with a concrete ramp?
Yes.
Without handrails? And isn't there a question of fact on whether or not he agreed to put a canopy up? Which would somehow prohibit the water from dripping onto the concrete?
Right. I'm glad you brought that up, Justice Montour. So the canopy and the ramp are entirely separate from this issue of the gutter. The gutter is what was pled. The gutter is what the plaintiff alleged is the issue.
She slipped on ice on the concrete ramp.
She slipped on ice. I don't know if it actually was at the point of where the concrete ramp had been constructed yet, but the complaint isn't that there's anything wrong with the concrete ramp. Now, the plaintiff keeps trying to shoehorn this issue of the canopy and can connect it with the gutter, which didn't exist. Frank Archer...
Your client denying that he agreed to put a canopy up?
No, he's not denying it, but the issue is that the canopy had nothing to do with any alleged dangerous condition. Frank Archer from the county called up my client and said, hey, look, would you mind putting up a gutter here so we don't have to deal with chipping ice out from the door and going in and clearing snow?
You said putting up a gutter. Did you mean canopy?
Canopy. I apologize.
Yeah.
Canopy. Yeah. Can you put up a canopy? My client said, sure. This is an improvement. There's no repair. There was no condition of which he was aware to repair. There's no dispute about that in the record at all. So the concept of putting up a canopy to address any gutter condition, that is completely false. That is not accurate. The canopy was there to deal with the county's snow removal issues. Frank Archer said, look, we can't get these guys to shovel the door. They won't shovel it from the door. We got to go there. We're always getting called out there. Can you put up canopy? That'll help us out. Nobody had fallen before. Nobody had fallen until that following December. And then suddenly it becomes this is a quote unquote dangerous condition, of which, by the way, the DMV employees were aware for years, 7 or 8 years they were aware of it. Lampak testified to that. Bush testified to that. Duffer testified to that. Everybody knew they stripped off of this gutter. It came down, everybody except my client. It came down and it blocked the doorway from opening. Not only was Mrs. Lampak well aware of the issue for many years, her husband runs a gutter company. So she started telling me at her deposition all about everything that was wrong with this gutter, which never made it back to my client. So there's no duty even if there is a construction if there's a constructive standard applied, which it should not, just because you might be aware that rain will come off a roof. Obviously, that's awareness of the general condition, which is insufficient under well-settled law. There's also no contractual duty, as we just discussed. The agreement was to erect a ramp, which he did. Erected a ramp. The canopy hadn't been put up yet. There was no time element. There was no agreement to say, look, I'm going to have this thing up by a certain amount of time. There's no connection to any actual gutter.
You should begin to wrap up, Counsel.
Just very, very quickly, I get understanding that open and obvious is generally defense, but when you have the facts here where the plaintiff, there's no dispute that the plaintiff, other DMV employees were very, very well with this condition for many, many years. She went in, opened the door every single day. They were complaining about this to the county. County never did anything about it. This is an open and obvious condition that should be a complete defense here. Should I argue with respect to the county's motion now as well?
You should address it. No,
Just
you're not going to get another chance.
Very quickly, very quickly, with respect to the county, I'm not sure I get the non-delegable duty argument here, because there wasn't an issue of something that an independent contractor did that was somehow faulty. That just didn't happen. Again, we have the disconnect between the creation of the ramp and the agreement to make an improvement for the canopy, which didn't address the gutter. The county had the duty. I understand that it said snow and it didn't say ice, but the county had unquestionably been doing this for years. They went in every single day, they checked it. The testimony is very, very clear that they had a duty. Just because it doesn't specifically say ice in there doesn't mean that they didn't contractually have a duty, because it wouldn't make any sense to make that duty the landlord's duty in under these facts. And they had assumed it. They've done it for 7 or 8 years. They very clearly assumed that duty. Just very quickly. I'll rest on my papers.
Thank you, counsel.
Thank you, Justice.
Good morning, may it please the court. My name is Peter Belauskas. I'm here for the plaintiff respondent appellants, the Lampacks in this matter. We are asking that this court affirm the denial of summary judgment to defendant Andrews and reverse that aspect of the decision that denied the plaintiff's motion for summary judgment. First, I'd like to start off by taking the position that, contrary to what you heard earlier, there is a contractual obligation here on the part of Andrews as the owner to remedy the condition here. The contract is quite explicit that it is the landlord's responsibility to make repairs. For any major repairs, which is defined as $300 in this matter, and all structural improvements. The record is quite clear that this canopy that the owner agreed to put up was much more than $300, which would trigger his obligation under this lease agreement. This is not a matter of just exercising a right to make periodic visits or examining. He had a direct obligation as the owner contractually to make these repairs in this case.
The repairs with respect to the gutter or the canopy, or both?
So specifically with respect to the canopy here, Your Honor, it was over $300, and that was the canopy that he in fact agreed to do. With respect to the framing of the issue, I would disagree that this is a matter of just a defect with the gutter at issue here. This is a defect with the roof, what would cascade water over the top. The building, according to the owner, lacked a gutter when it was turned over to the tenant. This is not a situation where the gutter created the issue. It was the absence of something to divert the water that came specifically down from the roof in this case. That is the obligation of a structural component. I would also indicate that the record is quite clear that the maintenance supervisor for the county informed Mr. Andrews quite specifically. 3 or 4 occasions he called him and said, there's water freezing up on this ramp, by the door, by the entrance, and it was continuing to be a problem since they took over the tenancy. So he was quite aware of this, which is probably why in April, when the request was made, that he agreed to put up this canopy. And he acknowledges that the canopy is there for the elements, for the purposes of the elements. The canopy still wasn't up by December by the time my client falls in this case. So it is our position that they had to contractually assume that obligation and are responsible for it. Additionally, as the owner has a non-delegable duty to keep a safe egress and ingress in this case. We submitted an engineering professional affidavit that indicates that the contractor hired by the owner in this case put up a ramp that created a dangerous condition. That ramp lacked adequate handrails that weren't appropriately tall enough, and there was no landing that was required by the property codes. So as the owner, they are vicariously responsible for that non-delegable duty in creating or contributing to this defect. The owner acknowledges that in the winter months when it's cold, that water runoff can freeze. And that's what we have here with this ramp that lacked a landing and appropriate handrail. So they're responsible for that position as well. And I'd just like to add that The non-delegable duty applies to tenants, employees that come onto this for the safe ingress and egress. There's no dispute that this is an ingress and egress, that it was a recurring condition, and the record makes clear that Andrews was well aware of this by Archer on 3 or 4 occasions about this. So we believe that the record is quite clear that there was a contractual obligation, there was also a common law duty to keep it safe, and that the owner failed in that obligation, and therefore there should be a denial of summary judgment to the owner and a granting of summary judgment to the plaintiff.
Thank you, counsel.
Thank you.
Good morning, Your Honor. Josh Lindy on behalf of Lewis County. I'll be brief because it's already been said a bunch. As to Mr. Andrews' statement regarding the gutter, Mr. Archer, who was the county's superintendent of public works at the time, he testified that he had no recollection of putting a gutter up. And then after that, we received a discovery demand for the audit trail. And that's how counties keep track of how they pay for things. The audit trail was from March of 2008 to December of 2016. There was no money indicated for any gutter. So the fact that Mr. Andrews feels that it's decided that the county put up the gutter is not true. The other thing is, as to the non-delegable duty, a commercial landlord that has a building that's open to the public has a non-delegable duty specifically to ingress and egress. And the cases that are cited in my brief state that pretty perfectly. And the last thing is, even though it wasn't argued in the underlying motion, my client employs the plaintiff, so any common law indemnification should be dismissed due to the workers' comp bar. That's all I have.
Thank you, counsel.
Thank you.
Next case is 846, Bilecki versus HBO Builders West Incorporated, 846. Justice Whalen is recused.
If it please the court, Richard Collins for the plaintiff and appellant. And we're asking the court on this appeal to reverse the lower court's granting of summary judgment to the defendant in this personal injury action. It's clear that the court below found that as a matter of law there was no proximate cause. So focusing on proximate cause, it's an issue. There's tons of cases, including from this court, that triers of fact, finders of fact, are generally left to decide those issues unless it can be established that the intervening act is so extraordinary or so unforeseeable that as a matter of law there's no proximate cause.
Can I just pause you for a minute? You said that the court found that there was no proximate cause.
Yes.
Did the court issue a decision of any sort?
No, Your Honor, just the
So
order.
there were 3 arguments that the defendant
And
made.
I'll address each one of them, if I
So
may.
we don't know, well, you say the court found this or that. We have no idea what
Very
the
well.
court's reasoning was, correct?
That's correct, Your Honor.
So it could have been the court found no duty. The court might have agreed with you on proximate cause and intervening act and so forth, but based its decision on duty, or it could have been the reverse. We don't know. We're left guessing.
If I could be permitted then.
Sure, yeah.
So in this case, just very quickly, factually,
Yeah.
what happens is the defendant owns an old pickup truck and has a snow plow on it,
Yep.
the blade.
And he's driving it to Rochester.
He's driving it to Rochester,
Plow is
that's
in the
about
wrong
40
spot.
miles. The dash, lights go off on the dash, he pulls over, he pops the hood, stands on the plow, checks the oil, is looking at not the radiator, but the reservoir for the radiator, starts to unscrew the cap. He said the cap was cool to touch. And then, of course, he's injured. The truck, there's certainly reason to believe that the truck overheated because of improper positioning of the plow. And as a matter of fact, one of the co-owners for the defendant believes that to be the case because there wasn't enough air coming in to cool off the motor.
Counsel, I looked for it on the record. I didn't find it. I just want to make sure it's not there. There's no evidence or testimony that there's anything written on the cap. or next to the cap.
Correct, Your Honor, correct.
Right,
No-
so your view, we've read the record, your view is that removing the reservoir cap, not the radiator cap, but
Right.
removing the reservoir cap is not, that's a normal and foreseeable consequence of the situation created by the defendant's negligence. It's not totally unforeseen or unreasonable for
Exactly.
somebody, when the vehicle's overheating, the lights on the inside
Yes.
said red, it's not wholly unreasonable to check to see if there's water there.
Correct.
To see if it needs water. Matter of fact, the trooper, who knew a thing or two about the
Fixed it.
vehicles, and he put water in.
And he fixed it.
Right, so that's your argument. If the court bases decision on that, you're saying that's incorrect? This is not so out of the ordinary like the other case that they relied on where somebody, the guy's putting gasoline to the carburetor and
And
somebody.
then try to start the car.
Yeah,
Right.
that is more unreasonable here than just.
Yes.
Opening the hood, seeing if it needs water.
Right.
This case is different from that.
And Your Honor, just very quickly, on the duty, whether the defendant owed plaintiff a duty, I think it's black letter law in New York State that the owner of a vehicle has to keep the vehicle in a reasonably safe condition for foreseeable users.
Right. If
And
there's a
so-
defect and you let somebody drive your truck and you know or should have known that the plow's in the wrong
Yes,
spot.
yes.
You should give them a heads up
Yes, exactly.
on the duty.
Yes. And also, I think the last point, at least, is raised by the defendant in its brief to this court, is that plaintiff knowingly exposed himself to a dangerous condition, which then gets us back to the one case you mentioned about pouring gasoline into a carburetor, but there's other cases where a fellow puts his arm and hand into the engine compartment of a skid steer, or a person jumps off a stalled elevator 6 feet onto a lobby floor, or a person climbs over barbed wire, or there's a warning sign, high power line, and then gets an electrical shock. Certainly the plaintiff, I think there's comparative negligence issues in this case, but there's no basis to conclude it's a matter of law. I would submit.
You would agree with me on this, I think, that you're not entitled as a matter of law to dismissal of this intervening superseding act. That you could still lose on that issue at trial.
Yes, the question is
You
of
just-
fact.
yeah.
The summary judgment, we're just challenging the summary judgment, Your Honor. I think everything is in play at trial.
Gotcha. Thank you.
Thank you.
Morning, Your Honors, and may it please the court, Nolan Hale for the respondents for HBO Builders West Incorporated. I'd just like to address with Justice Nowak your question about the warning on the cap. We don't know if there's a warning on the cap because the plaintiff testified that he didn't look for any warnings on the cap. He didn't look in the glove compartment to see if there's any warnings about if all the lights turn on in your dash, whether you should go into the engine and unscrew the reservoir cap.
Do you think it's common knowledge for motorists, people who are not experts, that if you take the reservoir cap off, that it's going to explode on you and you go flying back and up in the air and into the adjoining land? Is that common knowledge for people? Is it so obvious that that was an unreasonable thing to do?
I think it doesn't matter if I think it was unreasonable or not. I think the plaintiff testified that he would never open up a radiator cap when the car's over.
Radiator cap. He didn't open up the radiator cap.
He wouldn't, okay, I would argue that it's not foreseeable for someone to open up a coolant reservoir cap that he testified to when your car is overheating. And even if that is something you would do, he had his cell phone. He could have called his wife, who is the co-owner of our client. He could have called Mr. Misiak.
Well, his testimony is, what could they have done for me? They're in Buffalo. What's his wife or Mr. Misiak going to do for him? They're not there. They have no idea what's going on.
Well, exactly that. They had no idea what was going on. And that kind of points me to the part that they had no duty to warn him because they had no idea of any defect in the vehicle.
Do you agree that there was a defect on the vehicle?
No, I don't.
You don't think that the way the plow was positioned caused a problem for this vehicle to operate safely?
I believe that the plaintiff knowingly has volunteered to drive the vehicle that he'd driven before. He could have known to lower down the plow. The police officer knew it within minutes that that was the cause of the accident. And he had every opportunity to call Mr. Misiak, and Mr. Misiak testified that he knew that that could have been the cause of it overheating,
So it
was
sounds
the
like
plow.
What you're arguing here is there's no negligence, but that's not any of the issues we're faced with. We're assuming negligence here. This appeal is premised on the assumption that there was negligence, and that's how you framed it. But here, really, your argument is causation. It was not normal and foreseeable consequence of this car overheating that somebody would take off the reservoir cap.
Right, that's exactly it. There is no, we don't get to the point of whether there's any contributory negligence because the causal change between defendant's negligence and plaintiff's injuries were broken it's foreseeable to someone to go up and open the hood. That's totally foreseeable. We're not arguing that's not. But we are arguing that the cases show that unscrewing the cap, when he knew and testified that there was a danger, all the lights on his dash were on.
Didn't the trooper then put water into the radiator himself? He must have opened the cap.
I believe he just lowered the, he did do that, yes.
Right, so how is it reasonable for the trooper to do it and not this plaintiff?
He
By the
didn't-
way, this plaintiff wasn't like a novice. He would rebuild custom cars, so he was not like me. I mean, I could barely turn on a car.
I think the importance in that the police officer did that was after this accident happened, after the car cooled down to a point where he was able to do this. This was right after the accident. He got out of his car when it was still super hot, and then he opened the cap. The police officer did it way after the accident happened, and then he poured water in it. And I think that time is important here because...
How long after? How long did it take for the police officer to get there?
I'd have to rely on my papers, and I can't remember exactly the exact time that the police, I believe it wasn't long after, but it was long enough time for that the car cooled down so that he could pour it in.
So your argument is had the plaintiff waited that same period of time, just stood by the side of the road and waited, everything would have been fine?
I think he could have waited and he could have called a tow truck. He was never told that he had to make this delivery in super fast. He had to get the Geneseo and do it. He was never rushed by his wife or the co-owner, Mr. Misiak, to do so. He could have called a tow truck to do it. They could have showed him how to do that. He did call the police. He could have waited for the police to then say, okay, this is not drivable. You got to get a tow. Don't do anything. But instead, he waited. He didn't wait. He just took matters into his own hands and unscrewed it.
You'd agree with this. The standard isn't that, are there other things you could have done? That's not the standard for summary judgment, right? Standard is whether what you did, whether that was reasonably foreseeable.
Right, and I think the papers show and the case law shows that it was not foreseeable for him to do so. And I think with the distinguishable cases that
As
the
a matter
plaintiff...
of law. I mean, you
As a
could
matter
still
of law,
argue-
exactly.
You could still argue this to the jury, and you might well win.
I'd argue that we don't need to get it to a jury because there's no facts, there's no way of showing that this was foreseeable. And I think the plaintiff did not meet their burden in opposition to our motion summary judgment by citing cases where the plaintiff contacted their supervisor. Supervisor said, go ahead and do it. Do the act that eventually caused them to get injured. This never happened here. They're, first off, not an employee, so there was no duty for them to tell them of every single possible thing that could happen to the plow. He volunteered to drive it. And two, he never contacted our clients to do anything, and they never directed him to do so.
We understand. Thank you.
Thank you.
Case 847, Kroll versus New York State Department of Motor Vehicles. Judge Nowak, I think, are you recused on this case?
I am, yes, thank you.
Counsel, can you hear us?
I can, Your Honor. Can you hear me?
And we can hear you fine. Please proceed.
Thank you. May it please the court, Jason DePasquale on behalf of the appellant, Christopher Kroll. Your Honor, this is a situation where we're asking this court to overturn the department's finding of a refusal. The appellant in this case, and the record is clear on this, was taken to ECMC CPEP unit pursuant to section 2209 of the mental hygiene law. That's what the arresting officer testified, that he believed the appellant was so intoxicated that he lacked the capacity and needed to be taken to ECMC for.
And that's really the difference between your case and, say, a lot of cases where you have somebody who's intoxicated, and for them to argue it wasn't a knowing refusal because I was intoxicated. You're saying this is kind of another level up, right? This is a
Correct.
case where the officer recognizes a certain incapacity that's going on, and because of that, we now reach that threshold where he couldn't possibly knowingly refuse. Do I understand that?
You do, Judge, and it's refuted in the record that the officer read the refusal warnings while the appellant was at the ECMC CPEP. Now, in this case, and the proposition that Kate stands for actually supports our position, because at that moment in time, there is a statutory mechanism. The officer did not and should not have read refusal warnings to the appellant. He should have proceeded to get a blood draw. He did not need express consent. Mr. Crow lacked the capacity to give any such express consent or even refuse, and he could have and should have proceeded to get the blood draw of the appellant, and that has been held.
Counsel, even if he got a blood draw, wouldn't there still be a refusal? There's case law. The state relies on two Second Department cases. One is the Carey versus Melton, and one's Hickey versus DMV. And those cases, and I'm sure you read them, the Second Department says there's no knowing element here. As a matter of fact, that would lead to an absurd result, according to the Second Department. If somebody's so drunk that they don't know what they're doing, all the more reason that their license should be suspended. Those two cases support the state's position. Did the Second Department get them wrong there?
Well, Judge, I would say what distinguishes this case from the Second Department case, but is consistent with the Court of Appeals holding in Cates, is that when you lack the capacity, so there has to be some knowledge, some ability to understand to make an informed refusal, or any refusal, and be subjected to the penalties. Otherwise, there wouldn't be a requirement under the statute to give the warnings and to warn the motorist of what the implications could be. But
So
the
then
statute says,
if a motorist is highly intoxicated to the point of mania, so therefore can't make a knowing decision, the motorist says no when asked to take the test, but it's later determined he was so drunk that that was not a knowing and intelligent decision, then that motorist wins, in your view.
I would say no. Only what differentiates this case is there's an incapacity, and the officer specifically testified at the hearing that he determined the motorist in this case to be incapacitated.
He was incapacitated. He was incapacitated due to being severely intoxicated.
Yes, Your Honor, but I would submit, Your Honor, that if you're incapacitated, whether it's due to severe intoxication, whether it's due to a substance overdose, whether it's due to physical incapacity, incapacitation is incapacitation. And then the statute under 1194 2A authorizes the officer in that situation to just proceed and get a blood draw. And the Court of Appeals has said that is constitutional. You don't need express consent. That's the case holding.
Right, but that doesn't vitiate the refusal. The Second Department said as much. The fact that a chemical test was eventually performed at a hospital does not suffice to undo the defendant's prior refusal.
I would submit, Your Honor.
You disagree with the Second Department's analysis there?
I do, Judge. I believe Cates and in the statute that if you go under the avenue of 1194 2A and you get the blood draw because a motorist is either unconscious or lacks the capacity to consent, you're deemed to have consented, and therefore it's not deemed a refusal. And that's the situation here. Is the officer had determined the appellant lacked capacity, took him to the hospital for that purpose, relied on that statute of the mental hygiene law, and could simply have gotten the blood draw, and it would have been deemed consent by the statute, by 1194 2B, I believe, and that would have been deemed to have been consent, and it would have vitiated the refusal and the severe penalties that go along with the refusal. I would agree with Your Honor that mere intoxication does not overcome, no matter how intoxicated you are, the refusal element, unless, and what's unique about this situation, the incapacity position, and the officer specifically testifying before he even read the refusal warnings, he relied on 2209 of the mental hygiene law, made a determination.
Counsel, this makes for a very difficult standard to apply, right? I mean, if people drink to a state of where they're incapacitated. And so where they can't make a knowing decision, where they're not able to operate a motor vehicle. And so what you're saying is that when they drink to the point of being incapacitated, that's the difference right there. And you're relying upon the officer's assessment of that here to demonstrate that this had gotten to that point of incapacity and therefore they couldn't have knowingly consented, or knowingly refused, excuse me, the test. But it makes for a very difficult standard to apply, wouldn't you agree?
I would say no in this regard, Justice Whalen, that the Court of Appeals has said for that very reason, and the reason under the statute you can just proceed and get a blood draw, is that it would not have violated the Fourth Amendment or the Equal Protection Clause of the Constitution by virtue of that. So when you have a motorist that is so incapacitated for any reason, whether it's due to intoxication or physical incapacitation, the statute allows the officer to get a blood draw without making an application for a warrant, and you have consented to that. And the Court of Appeals has said for that very reason, Your Honor, that we're going to put that mechanism in place, that automatic consent for that situation, and hold that does not violate a defendant's Fourth Amendment right or equal protection right in the context of suppression hearing for that very reason. Otherwise, it would put the state in enforcing DWIs in an untenable situation. So I believe that was recognized by Cates in the Court of Appeals and by the legislature in the statutory framework in saying, if you find yourself in this situation, it bypasses the warrant requirement under the Constitution. Go get the blood draw. That is constitutional, and you have deemed to have consented to that as a matter of law when you were given your license.
I think we have your argument, counsel.
Thank you, Your Honors.
Thank you.
Good morning, Your Honors. Doug Wagner on behalf of the DMV. It seems to me that everyone agrees that the Second Department has squarely rejected this argument. The Third Department also did in a case that the DMV cited, Gagliardi. It's in our brief and also in the appeals opinion. The only argument the petitioner is left with here is that in People v. Cates, the court used the term incapacitated or unconscious, and then also in the MHL, in a totally unrelated statute, the legislature also used the term incapacitated. But if the court looks at the MHL law, there's two relevant definitions. The first is whether or not the individual was a danger to himself or others because he was incapacitated by alcohol. The second is whether or not he was able to make a rational decision about his health care. So neither of those are actually applicable to this case. The question here under 1194 of the VTL is just, did he refuse? Here in the record, it's clear that he said, I do not want to do that. That's all that is required. And the petitioner's reliance on People v. Cates fails for another reason. As cited in his own brief, he cites the legislative history. The legislative history here from 1955 said, the reason we have the refusal warnings is so that when there is an awake and conscious driver who says, no, I don't want to do that, the officer doesn't need to get in a physical altercation with the petitioner, with the driver. So here, the officer said, do you want to take the refusal? He said, no. The legislature has already prescribed what happens in that situation. They have their license revoked because they voluntarily refused the
If counsel is correct in what he's saying, in this case, somebody who's conscious, who's highly intoxicated, the police officer or medical personnel has to wrestle with this guy and try to jab him in the arm or somehow get his blood, and Lord knows what's going to lead there. That's the steps that defense counsel is saying should have been taken here.
That's exactly right. That's exactly what he is arguing, and that's exactly what the legislature has said is not the law in their legislative history. And also, the fact that the Second and Third Departments have rejected this over the course of 50 years means that if this court stepped in a different direction, it would essentially vitiate the entire scheme, because anyone who would have a hearing before an ALJ would make this exact argument, and then it would create a system by which courts and ALJs were drawing lines about how incapacitated an individual would be, and it would create the perverse incentive of officers not to look after the safety of the citizens who are incapacitated by alcohol by giving them health holds at local medical centers, because then they wouldn't have their license revoked.
I think we have your argument, counsel.
Thank you.
Thank you. Case 848, Zinda versus Wade Pro Tire Repair, Inc. Mr. Connolly, can you hear us?
Yes, Your Honor, thank you.
Very good, we can hear you also. Please proceed, counsel.
May it please the court, here on behalf of Scott Wade and Pro Tire Repair, this is our appeal regarding denial of defendant's motion for summary judgment and opposing plaintiff's appeal regarding denial of their motion. The facts of this case fit squarely within the emergency doctrine. My client was driving along on I-81 in Hastings. There was inclement weather. It had been snowing. He's driving in the left lane. That was the clearest lane. He slows down to account for the weather conditions. He doesn't pull off or anything. Neither does the plaintiff who's driving at some point ahead of him. There's no cars off the side of the road. It's just a winter weather driving day, and they're driving along, and all of a sudden comes upon what could only be described really as like Armageddon. There's multiple jackknife tractor trailers. There's cars off the road, and they are blocking both lanes of traffic. So the plaintiff, who's about a minute or two ahead of my client, doesn't recall anything following behind him, so there's not an issue of following too closely. He makes the decision, I'm going to pull off the roadway and go to the left. Can't proceed forward because, again, both lanes are completely blocked. So he pulls off about 15 feet into waist deep snow and into the swale on the side of the road. A minute or two later, my client comes along and encounters the same blockage in the road. And he makes the same sudden decision, I need to go to the left, I can't proceed forward, and he goes off to the left. Does not see the plaintiff's vehicle and comes in contact with it as he's proceeding off the left side of the road to avoid what was in front of him.
I think what the plaintiff's theory is, though, that Mr. Wade was driving too fast with the truck given these conditions. It sounded like it's blizzard condition. It wasn't just this Armageddon of the trucks jackknifed. It was very snowy, visibility limited, and he therefore, because he couldn't stop in time, was going too fast for the conditions.
But that's speculation. So both vehicles had to have encountered this at about the same time because they both went off at the same area of the roadway. His statement that my client, or suggestion that my client was going too fast, is nothing more than speculation, which this court has held is insufficient to overcome summary judgment.
Well, he was going too fast to avoid hitting the plaintiff.
But he doesn't see the plaintiff. That's the point. That's kind of an important point here. So the suddenness of this, he's disturbed by what he sees in front of him. He doesn't see the plaintiff and has no reason to expect that there's a white car parked 15 feet off the road in the swale, and he's thinking, I have to get off the roadway, just like the plaintiff made that same decision before.
But I mean, the reason why your client decides that I've got to get off the road is because he apparently is seeing something ahead of him, the jackknife tractor trailers, the other cars that are pulled over, and so he's able to see some distance in front of him, and he makes this decision to pull off to the left side, similar to what the plaintiff did. Isn't whether or not that conduct's reasonable, isn't that one of those just questions you throw to a jury and let a jury decide it?
In this circumstance, plaintiff claims that what he did was reasonable, so if what he did was reasonable, my client made the same decision. They both went to the left because they were in the left lane. To them, that must have made sense.
Does it make a difference if plaintiff was able to pull over and not hit somebody else, but your client, in the same circumstances, pulled over but struck the plaintiff?
Well, the difference is the plaintiff had a clear path at that point because at that point there were no other vehicles over there. My client doesn't have the benefit of a clear path at that point because by that time, plaintiff had already decided he was pulling off into the waist-deep snow. And again, at that point, my client has no reason to expect there's another vehicle that's already driven into this deep snow.
Did they both pull over, they got off the road and went into the median area, to the swale? They did that because they couldn't stop in time to avoid hitting the vehicles that had stopped in the road, right?
I'm not sure that that's necessarily in the record. My client went off, and I believe plaintiff went off because they couldn't proceed forward, and they wanted to avoid.
Well, why not just wait in the road? Why do you go off into deep snow?
I think that's part of the emergency. I mean, you are reacting with little or no time for thought. That's the whole point of the emergency doctrine. So whether that decision to go to the left or to drive forward and be parked in the road and possibly become part of that larger accident, That's the whole point. They had little or no time to react. So, and to Justin Whalen, to your point, this court decided in the Lester case back in 1998 that this could be decided as a matter of law. In that case, there was a multi-car accident on the exit ramp. So exit ramp, middle of I-81, main thoroughfare, I don't see a distinction there. It's not to be expected that both lanes are going to be blocked. I mean, I think as drivers, we can anticipate that, accidents are going to happen. There may be things that you need to watch out for, a deer crossing the road, but as a driver, I don't think we need to anticipate something like this. And there were pictures in the record.
To follow up on Justice Lindley's question with reference to whether or not your client acted reasonably, that's part of the emergency doctrine too. It's just no matter of fact, hey, there's an accident here, jackknife on I-81, I got to get out of the way. Was it reasonable for your client to make that same effort? Or could he just stopped in the road and the left lane there? He couldn't have gone any further anyway.
Well, I think what we have here is plaintiff.
And that's a question of fact.
But plaintiff making the same decision and saying, I was reasonable, I went to the left. Well, that's exactly
and
what.
Again, the plaintiff was able to slow down and stop, while your client apparently, whether or not he was at a reasonable speed or not, went into the median, 50 feet crossed into a foot of snow, and then landed, stopped on the other side of the median.
Well, I think
that's not really a stop on just on the side pulling over on the side.
Well, neither was plaintiff. Plaintiff's driving a two-wheel vehicle, a car, and claims he came to a controlled stop, but I don't think anybody here would agree that a two-wheel drive vehicle can just drive into waist-deep snow in a controlled manner. It doesn't happen like that, and my client was driving
Well, it sounds like it's all an issue of fact, whether or not they both did.
But I don't see this as being any different than in Lester. Like, when you approach something like this and you see it, and that's an emergency, and how you react, he reacted in the same manner as the plaintiff. And in
The plaintiff
Lester,
was able to pull off to the side.
but that's exactly what my
Your client went into the median, over the median, across the other side of the road.
But my client's also driving a much larger vehicle.
Well, maybe he was going too fast.
Okay, but I don't see it as any different than, Lester, where the court said it, that could be determined as a matter of law with respect to.
You're making a lot of good arguments. Just a question of should they be addressed to us as a matter of law or to a jury? That's really what the question is.
Do you want to address your point two with respect
Sure,
to the injury not being causally related?
Sure, so we also moved with respect to serious injury threshold. In this case, plaintiff's only alleged injury is an inguinal hernia. He had no complaints at the scene. The day of, his shoulder was hurting him. He said his hip hurt him. He made no complaint of any type of pelvis pain or any issue related to that. The next day, he's picking up a rental car, and he describes lifting up his leg and feeling a pop. We retained an expert, Dr. Thomas, who reviewed all of the medical records, and he actually rendered the opinion that there's not even.
Let's assume for the sake of argument, counsel, I don't mean to interrupt you, but assume for the sake of argument that you carried your burden initially. How is there not a question of fact based upon the proof that the plaintiff put in relative to the relationship of the injury to the accident?
So they're relying on an affidavit from plaintiff's primary care doctor, and his affidavit is deficient for a couple reasons. Number one, he relies on a false narrative. He relies on the fact that the plaintiff was struck behind by a tractor trailer going 55 miles per hour, and that's not in the record in terms of what exactly happened. Also, he says that plaintiff had no prior complaints of any type of inguinal hernia or pain there, but he makes no mention of when he had last seen the plaintiff. And this is important because if plaintiff hasn't seen his primary care doctor in 6 years before this happened, then that would be a relevant point. Well, he can't just say, well, he didn't have this before. You haven't seen him in 6 years. He doesn't attach any prior records. He doesn't say when the last time he saw him was. And on the last point, he was also mistaken about the cause of the testicular pain that he's relating to this inguinal hernia. He says that started at the time of the accident and progressed thereafter. That is not in the record. Plaintiff was very clear that pain started after his first surgery. So, he's relying on things that just aren't supported by the record.
Thank you, counsel.
Thank you.
Mr. Conway?
Good morning, Your Honors. May it please the court, my name is Andrew Conley. I represent the plaintiff's respondents in this matter. What we have here, Your Honors, is a situation where both vehicles come upon the same scene, but the results are very different with both vehicles. My client testifies he's proceeding around 20 miles an hour, and when he sees the scene ahead of him, he slows way down, essentially coasts into the median. The defendant comes upon the same scene doesn't know how fast he's going, doesn't know how far he is from the scene ahead of him, drives into the median, apparently never sees my client, doesn't check to see if there are any vehicles there. It's my client's vehicle in the rear and is going so fast that he continues through the median all the way to the oncoming side of the road. Certainly an issue as to whether his speed was reasonable for the conditions. It seems that the defendant's vehicle was totally out of control at that point. As your honors seem to indicate, there are clearly questions of fact here about whether the emergency doctrine even applies and whether the defendant's conduct was reasonable in light of the scene that he came upon. With respect to the injury portion, your honors, there's certainly a question of fact here. They have an expert, we have an expert. Our expert is our primary doctor, who says that the plaintiff never had any complaints like this before, and relates that injury to the accident. And certainly a question of fact there for a jury. Unless your honors have any questions, we'll rest on our papers.
No questions, counsel. Thank you.
Thank you.
Case 851, Friedman versus Town of Dunkirk. Counsel, you're appearing pro se here, is that my understanding?
Yes, Your Honor, I am an attorney, but I'm representing myself.
Very good. Please proceed.
Good morning, Your Honor. May it please the court. My name is Jennifer Friedman from the law offices of Jennifer L. Friedman, PLLC, and I'm representing myself as a homeowner of the property at 5186 Woodlands Avenue. I'm asking the court to reverse the lower court's decision, annul the zoning board's determination, and declare that short-term rentals are allowed in zone R1 in the town of Dunkirk.
Counsel, is one of the issues here, let me put it that way, that the trial court in rendering its determination here did not limit itself to the determination that we find in the ZBA ruling?
Yes, Your Honor. The Court of Appeals in Sherburne specifically held that the trial court is limited to the grounds in the ZBA's, or the agency's decision, which would be the ZBA in this case, and they did not rely on those grounds at all. They found new grounds, which is impermissible.
We'll take a look at that, counsel.
Yes, so, very, very quickly, with respect, the ZBA found that the single-family home located on the shores of Lake Erie was not a single-family home because it's not, it did not meet the definition of family. The lower court did not rely on that at all. And frankly, the lower court only mentioned the word family twice in its decision based on different contexts on record page 4 and record page 8. So the lower court instead attempted to find new grounds, namely that the zoning court did not specifically list short-term rentals, but the lower court also found that long-term rentals, which are not mentioned anywhere in the zoning code, are allowed. And it is undisputed that long-term rentals are allowed by the zoning code. So then the lower court then found that I was conducting a business activity. However, the ZBA's written decision and the ZBA's resolution, neither of them mentioned the word business or rely on that anywhere in its decision. And it is undisputed that the home is a single family dwelling. The ZBA specifically, even though it was argued, did not find that the home was not a dwelling unit. They relied simply on the fact that a family did not reside there. It is undisputed that people who use the home use those for purposes like eating, sleeping, showering, entertainment, etc. Since the lower court relied on new grounds pursuant to the Court of Appeals authority in Sherburne, this court, on that basis alone, should reverse the lower court's decision and declare that short-term rentals are allowed in Zone R1 in the town of Dunkirk. Respondents' arguments relating that the zoning code specifically bans short-term rentals is without merit. There's nothing in the zoning code that prohibits short-term rentals.
And is your argument, counsel, is your argument on that point that if it doesn't preclude it, even if it was ambiguous with respect to it, whether it included it or not, that the ruling ought to go to your favor and not to the municipality's favor because of the strict construction of the zoning code rules?
Yes, Your Honor. And I also point out that respondent's argument, which relies on section 190 of the zoning code, the definition of dwelling, the town specifically defined dwelling as a building or portion designed or used exclusively as the residence or sleeping place of one or more persons. Then there is an exclusion in there, which includes boarding houses or rooming houses, tourist homes, motels, hotels, or other structures designed for transient residents. This is a very important point, Your Honor, because the town did not use the term used or designed for transient residents, only designed in the exclusion. And it is undisputed that this 3-bedroom single-family home is a single-family home. It was not designed for transient residents at all, which would have things like, public areas, lobbies, communal kitchens, things like that. So the zoning code is very clear as to what is not a single-family dwelling unit. If Your Honors have any questions about the definition of family relied on by the ZBA, I'm happy to go through that. But looking at the canons of statutory construction, the definition of family has a subpart relating to whether they are transient. However, that does not allow a basis for a whole term prohibition on short-term rentals, because under section 190 of the zoning code, the definition of family, you do not get to the transient element until you go through the first 3 steps. The definition is quite lengthy. I am happy to go through it, but as I said, it is very lengthy. It's set forth at length in the petition.
Counsel, we have the ability to review that. Thank you. Do you have anything further?
I do not, Your Honor. I just would like to rest on my papers for the remaining arguments.
Thank you, Counsel. Proceed, Counsel.
May it please the Court, Henry A. Sommerfeld on behalf of the Town of Dunkirk respondents. I wish to begin, Your Honors, with the framework here, which is not contested. Petitioner owns a single-family residence that's located in the R1 district, and petitioner bought that property and uses that property as a short-term transient rental. As the record reflects, she advertised on Verbo. That's not at issue. The question is one of interpretation of the code, and I wish to begin with petitioner's arguments and the dialogue with the bench as far as what the trial court determined.
Well, can I ask you this before you do that?
Of course, Your
Where in
Honor.
the code does it say, in an R1 district, it says the only permitted use is single-family dwelling? Where in the code does it say an owner of a single-family dwelling can't rent it out on a short-term basis?
Well, looking at the definition of dwelling, Your Honor, it says any use that's not listed is prohibited. It excludes all short-term transient rentals from the definition of dwelling.
But, Counsel, if you frame the use specifically enough, you can frame the use any way you want. If you make it real specific, you can say, well, it's not covered then. And if it's not covered, you have to seek permission under, I think, Section 183.9 to make the request of the Zoning Board of Appeals and say, gee, will you permit this? But it all depends on how you frame the use, right?
Well, not necessarily, Justice Nowak, and to address that comment and Justice Lindley's question, the word dwelling shall not include boarding houses or rooming houses, tourist homes, motels, hotels, or other structures designated for transient residence.
Designed is the key word. Ms. Friedman was just arguing that it doesn't matter, it doesn't say use, it says it's built that way, separate bathrooms, separate entrances, and so forth. She relies on the word designed.
I understand, Your Honor, and that's an important distinction, but if Your Honors look to Zoning Ordinance 189.6, it goes on to define usage as including intended, arranged, or designed to be used or occupied for. And of course, if this court were to accept petitioner's argument that because her residence, her single-family residence, was not designed for the purpose, she could use her residence for anything, as a clinic, as a hospital, as a hotel, which certainly would not be the intent of the code, and that's not what the code provides, particularly when reading Section 189.6. What we're dealing with here, Your Honors, is a simple question, which is whether or not the
town contemplated and permitted short-term transient rentals in the code, in the zoning ordinance? And the answer to that, as the trial court correctly held, is no, these are not permitted uses.
Did the trial? Don't you have two problems here? One is, as she stated, that the decision has to be limited to the ZBA's grounds, and it wasn't. And the second is, the town really just needed to update its ordinance, which it never did either, to prohibit short-term rentals.
I'll take those both in turn, Justice
Okay,
Greenwood.
thank you.
First, with respect to the trial court's holding, when you look at the trial court's holding and you compare it to the ZBA's determination, both the trial court and the ZBA found that based on the reading of the code, short-term transient rentals are not permitted. And I'll just briefly read, I know the court has this, but it's worth mentioning. Starting on record page 5, the zoning ordinance in the town does not list vacation rentals or short-term rentals as permitted uses, nor is it listed in the type of uses that may be applied for a special use permit, nor does the definition of dwelling include such uses. And this is exactly what the ZBA found. If your honors look at record 730 to 731, that is consistent. Now, the trial court does, in its rationale, use the term business. And the trial court does so in the context of highlighting that businesses aren't allowed in R1 districts. Why? Because the community wants quiet. The community wants to maintain the community character. It was a piece of rationale, but it doesn't overturn what the court ultimately decided, which was that the code, its plain reading, and the language does not permit this. So we disagree, of course, with petitioner's argument in that respect, Your Honor. We think they are consistent when read. And even if there was some additional rationale, the holdings are consistent. And this court can certainly look at the code and find similarly that these uses are prohibited. And to the second point, Justice Greenwood, that you raised, which I apologize, do remind me.
That had to do with prohibiting short-term rentals, that they could have just done that.
They could have updated the legislation, the code, right?
Right, and I think that's in the record that was argued also.
The town certainly
Acknowledged.
The town certainly could have, Your Honor, but before the court at this moment is the code as it existed then, and that did, I would say, expressly prohibit R1 district. And another thing the court can look to is, look at the other districts, R2, C1, C2 districts. These type of transient rental uses are expressly permitted there, either with a special use permit or some other approval. That confirms the intention of the town to exclude it in the R1 district. Otherwise, it would have just...
Does the record, maybe I'm confusing this with another case, but does not Ms. Friedman assert that there's other homeowners in the area who rent it out on Verbo and short-term rentals?
I believe she does raise that, Your Honor. However, that's not in the record as to whether or not that was ever brought to the attention of the town or whether or not it was ever investigated. That was raised, and it's speculation because we have no confirmation of what others are doing. What we know is, indisputably, Ms. Friedman is renting her home as a single-family residence in the R1 district for the purposes of a short-term rental, which is essentially a business operation. It's a money-making operation, and it's something that the code does not permit. And, you know, I know Ms. Friedman didn't raise this, but I do want to mention the vagueness aspects. The vagueness, it's a meritless argument because the code puts reasonable persons on notice of what is and is not permitted. Yes, there are certain references, as the zoning code is, to this section and that section, but we don't have to define every single term in the zoning code with specificity. That's not what the law requires. Here, if you look at the zoning ordinance in the R1 district, this type of use is not permissible. And if Your Honors look to section 189.6, which deals with the design versus used for issue that Ms. Friedman raised, it further confirms that this is not vague. This is a prohibited use, and we would ask that the court affirm the trial court.
Thank you, counsel.
Thank you, Your Honors.
Case 852, Amoa versus Amoa, and I apologize if I'm mispronouncing the last name. Justice Montour is recused on this case. Appellant's counsel is appearing by video.
Your Honor, we have counsel. We're just waiting for him to turn on his camera.
Thank you.
He's thus far non-responsive, Judge.
Okay.
But he's connected to the call, but not responding.
So there's no, in other words, can we get him on a telephone line?
We can try that. Take a little bit.
We'll give it a minute or so. See if you can. Mike?
Yes, Judge. Thus far, we're not able to get him.
We're going to deem appellant submitted. Mr. White, would you like to be heard?
Good morning. May it please the court, Justin White on behalf of the respondent, Rachel Amoya. Our position here is that overall, from the start of the experience my client had on April 7th of 2020 till the end of the session, which lasted 45 minutes, she was placed under an extreme set of circumstances and forced to sign an agreement that was unconscionable. It started out with misrepresentations in the agreement about her being familiar with the Child Support Standards Act. It continued with Mr. Amoya providing her self-made explanations of what the law was, one of which included the statement that she was not entitled to any spousal maintenance. It involved him being the primary custodial parent within an hour of them sitting
He vastly
down.
understated his income. Let me ask you this. The husband seems to suggest that because, for the duress issue, that because the threats that were being made, he was not threatening to engage in any illegal behavior. Therefore, there's no duress under the law here. He was threatening things that he could do within the confines of the penal law.
Well,
do you agree with that definition of duress?
Absolutely not. In fact, all one needs to do is peruse Penal Law Section 245-15, which makes it a crime to disclose private images of a sexual nature. That's a crime on the books.
But couldn't there be duress even if he didn't even if he didn't violate the penal law? He was threatening to do things, tell people about certain private matters.
Particularly his own children.
To his children.
Yeah, to his own children. I mean, it was egregious what he was threatening.
So that's
to do.
duress even if he couldn't be prosecuted for that.
Correct. Yeah, he didn't have to be prosecuted. And look, this was an extortion, if nothing less. And it continued through the unconscionability part, the fact that his income was lowballed to the tune of about 50% of it actually was. There was nothing here that didn't make it bad. And she was, and furthermore, when you watch the video and you take in the wife's reaction to this experience, this poor woman was beside herself. She was in tears. And then he had the brother sitting there like a catbird with his video camera on, and then a notary out in the driveway to come in and do the notary. And then, oh, by the way, here's $5,000. get out, you can see the kids in a local park. This was horrific.
Yeah, we're very familiar with the facts of this case.
Okay, I won't
Counsel.
stress them any further.
Thank you.
Thank you for your time.